Good morning, sir. Uh, with your permission, may we start?
Good morning, yes, please.
Sure, sir. Mooting is a bridge between knowing the law and effectively wielding it. It is where legal theory becomes a compelling argument and where future advocates learn to stand confidently at the intersection of knowledge and persuasion. A very warm greetings to one and all present here. I, Anjali Sharma, on behalf of Rajasthan School of Law for Women, welcome you all to the first session of the National Moot Court Training Workshop organized by Rajasthan School of Law for Women. Moot court is a valuable component of legal education that hones students' research, writing, and oral advocacy skills. It requires thorough preparation, effective teamwork, persuasive argumentation, and professionalism. By mastering these fundamentals, law students can excel in moot court competition and develop critical skills for their legal career. Today, we have with us Mr. Gaurav Pathak, sir. We welcome you, sir. Sir is an assistant professor at Jindal Global Law School. Sir holds a BA LLB honors from Dr. Ram Manohar Loya, National Law University, Lucknow, and LLM in Information Technology and Intellectual Property Informatics Study Program from Leibniz University. Prior to entering academia, Sir worked as a dispute resolution attorney with a New Delhi-based law firm for over 5 years. News reports covering his work have been published in in the Hindu's Times, Bar and Bench. Appeared in several TV discussions. Sir's research interests are technology law, consumer protection, and dispute resolution. Before beginning with the session, there are some guidelines for the participants. The participants are requested to kindly adhere to the following rules while attending the workshop. All the session attendance of all the session is mandatory, keeping your video on and audio on mute. At the end of session, a feedback form link will be dropped in the chat box, which must be filled to receive the participation certificate. Will be provided by Google Drive.
Moderator?
There is some network problem. Just a second.
Okay, fine.
Am I audible?
Yeah.
Now, I would request Mr. Gaurav Pathak, sir, to commence the session. Over to you, sir.
Thank you so much and good afternoon. I'll just start with my presentation. Please give me a second. Yes, is my slide visible?
Yes, sir.
Yes, sir.
All right. Great. So thank you, first of all, for giving me this opportunity to speak to all of you. I'm going to talk about fundamental of mooting for the next hour or so. I would like to have a question answer session in between so that we can answer all the queries that you might have regarding this session. My name is Gaurav. I graduated from law school in 2016. While I was a law student, I participated in a few moot court competitions. Since I've graduated, I have assessed many moot court competitions, both on the national level as well as the international level. So I believe I would be able to give you some perspectives which might be helpful for you to participate in a moot court competition in an effective manner, as well as what are the certain things that judges look out for while assessing moot court competitions. In case you have a question at any point in time, please feel free to stop me and I'll be happy to answer it then and there. And you can also have a question and answer session at the end as per what you like. Overall, my presentation is going to be in several parts. I'll start with an introduction to mooting. How do you prepare for a moot court competition? What are the necessary components for a moot court competition, such as doing legal research and case analysis? Writing memorials is one of the most crucial parts in a moot court competition, followed by oral advocacy, which is the oral arguments that one presents. Overall, the structure of a moot court, what are some tips that you should have in mind, followed by a question answer, and then we'll stop this presentation. Just so I begin with, can I get a show of hands from people who have participated in a moot court before? What is the audience? And yes. Okay, so that's a good number, yes. So can anyone from you volunteer and tell me what was your experience like? What learnings did you get from the moot court competition? Anyone?
Sir, first of all, we got to know about how to do legal research. Sir, it is a crucial part, as you said. Sir, legal research is a very important part. And about advocacy, that how we can present our case in front of judges. And judges always keep us very मतलब हमें थोड़ा सा मतलब मोटिवेट करते हैं कि भाई बड़े कैसे मतलब मूड कोर्ट को कैसे करना चाहिए और ऐसे
जी right. Does anyone mind if I speak both English and Hindi? I would want to know what are you more comfortable with. Is there anyone who does not understand Hindi at all? All right. It'll be tough to know without someone speaking up, so it's okay. The question before us is, what is a moot court competition and why should one moot? So perhaps the first glimpse of a moot court competition that I got was a law student and an aspirant to become a law student in one of the national law schools in India. The brochure that CLAT had circulated had moot court as one of the prominent features in all the law schools that had been a part of CLAT at that time. Zara, you have a question? Yes? All right. So yes, that was my introduction to moot court as a word in itself. So in law school, one of the primary objectives is to give you a law degree which equips you to become a lawyer. Now, the difference between a lawyer and an advocate is that a lawyer is a person with a law degree, an advocate is a person with a law degree who is also registered with the bar and accordingly has the privilege of speaking in a court of law. A moot court tries to mirror this activity. For example, once I graduated, I became a lawyer. I could speak in an actual courtroom. While I was a law student, the endeavor of the college or the endeavor of the system was that I should be made familiar with certain activities which are very similar to speaking in a courtroom. And this activity is called a moot court competition. The factual problem that is given in a moot court competition is of course not real, does not have a direct bearing. The whole purpose of the competition is to ensure that the participants get almost a lawyerly like feeling of being able to speak in court, and also the stuff that happens before, which is to research, prepare arguments, make written submissions, and then finally make oral submissions. One of the crucial differences that is there in a moot court competition and an actual courtroom is that in a moot court competition, everything happens as a final round. It is the place where you make your arguments on all issues. Whereas in an actual courtroom, you get several days and the whole proceeding takes over a long period of time. So in that way, a moot court competition is only trying to mirror the final arguments that might happen in an actual courtroom. So therefore, at the outset, I should make it very clear that in case you do not have a good moot court experience, I mean, whenever you go out for a moot court competition and you do not do as well as you thought you would, do not take it to heart, because it is nothing like what happens in an actual courtroom. Nevertheless, it is important to understand what is a moot court competition and take it with all seriousness, because it is one of the competitions, it is one of the avenues within a law school framework which will help you become a better lawyer and even enhance your multiple skills which might be of different use to you, even if you do not want to become a lawyer at the end of the day or to become an advocate at the end of the day. It is an essential component of legal education because it is the only thing which comes close to being like an actual courtroom. The real life scenarios that you get in a moot court competition help you become a better person with respect to understanding certain facts. It is the nuances that matter, and it is the processing of those nuances within your mind and your ability to understand them, process them, and then reproduce them in an understandable way is what make you a better mooter as such. In a typical moot court competition, there are multiple teams, but in a mock courtroom, a single courtroom, there would be at least 2 teams, and they would be judged by a number of judges. It could be a single judge, it could be multiple judges, depending upon the format of the competition. Mooting by itself is not something that is really new to India. I have met people who are now senior judges, senior lawyers, who were mooting in their own law school years as back as 1980. So it is not a new activity. It has been here for a long, long time. However, its prestige, its growth has been tremendous. It has really grown over a period of time. Earlier, if there were 1 or 2 moot court competitions, now there are several, more than 20, 30. I mean, the number is endless. But of course, those moot court competitions differ as per their quality. There are some really famous moot court competitions, and then there are some upcoming ones. Having said that, one should consider any moot court competition that they get and should try to perform to the best of their ability in that particular moot court competition. Apart from the legal skills that you learn in a moot court competition, one of the more important skills is interpersonal skills. How do you interact with your co-participants? How you work in a team? How you interact with the judges who are going to judge you at a moot court competition? All of this translates into networking opportunities. You make friends, you make contacts, and of course, law is a profession in which your contacts are really going to be helpful going forward. And this competition is a platform which really gives you that opportunity to. This platform really gives you that opportunity to connect with people and perhaps grow in your career and life accordingly. How do you start preparing for a moot court competition is the next thing that we are going to cover. So this process typically begins by, first of all, looking at the calendar of moot court competitions that are going to take place in a particular year. In most of the universities, first an intra is usually held. It's a mock intra. It's a competition conducted within that college, and teams are ranked accordingly. Such teams can bid for a moot court competition, can select the moot court competition to which they would want to go. So, I mean, assuming that has been done in your institution or would be done, the best way of selecting a moot court competition involves several steps. First, identify the subject area in which you would want to moot. For example, I am a master's degree holder in information technology law, and IT law was one of my favorite areas when I was a law student, accompanied with certain other subjects. If I wanted to do a moot court competition, it is natural that I would want a competition that aligns with IT law, or at least has some shade of information technology law within the moot proposition. The reason for this is that I would be spending bulk of my time doing research, preparing for a subject area which I'm going to practice after I graduate or when I become an advocate. All right. Similarly, even if there is something that you do not really want to practice after you graduate from law school, but are casually interested in or are genuinely interested in just as an academic pursuit, you should follow that up. The reason why I will not suggest you to go for a moot court competition which does not have any bearing with your likes or choices is because a moot court competition requires serious preparation. And in case you choose something about which you are not that serious enough, it is going to give you a hard time and might dissuade you from participating in a moot court competition. And that is something that no one would want to do, right? So choose a competition as per the area of law to which that moot proposition pertains to. How do you get to know that? For legacy moot court competitions that have been taking place for a long period of time, you already know what kind of a problem could there be. For example, if you talk about Stetson moot court competition, it's an international moot court competition. It is mainly on environmental law. A Manfred Lachs moot court competition is always on space law. Coming into India, there's a KK Luthra moot court competition which deals with criminal law. All right. So if you actually see the history of a moot court competition, you will get a very fair idea as to what the moot proposition is most likely going to be on. The second factor that you should look into is the location of the moot court competition. This becomes important because, like any other activity, this competition also has certain costs. You as a team will have to pay the registration fees. You will have to submit memorials, that is the written document that are submitted to a moot court competition. And also, in case you're selected, you'll have to go to that particular location for that moot court competition. Now, I mean, if there's a moot court competition in Goa, I am sure it will be very famous, but you'll have to think of it from multiple points of view. Just because there is a moot court competition in Goa and you would want to go would not make sense. But if that is a moot court competition that deals with a particular subject area that you like and it's also in a good location, definitely there is an added incentive of going and participating in that moot court competition. Location also matters from an international viewpoint. For example, today is 21st of September. There's a moot that is going to happen in the United States in December, which is an excellent moot. But can you really go to US in December if you do not have a US visa already? The chances are unlikely, because the visa wait time in India is huge. So even though you might be very good mooter, you might have prepared really hard, but a little bit of bad luck and a little bit of timing can have a huge impact on your overall career as a mooter, or for at least that moot court competition. So be very thoughtful about both the subject matter and location, because both are equally important. If you choose a location, if your moot is going to be held at a location which is very hard to reach, or there are some hiccups along the way, it might give you more stress than the moot proposition itself. The even more crucial part is forming a moot team. Now, this is where either friends are made for life or existing friendships get broken. And that is because you might have certain expectations from each other, but it is important to understand that a moot court competition is an endeavor where you need people with certain skill sets. All right? It's not necessary that your friends might have that skill set. For example, and the reason why this is called a moot court competition is because it tries to mirror what happens in actual life. In an actual courtroom, you might get a chance to work with other lawyers who might not be your friends. They are just good lawyers and you have a good case and your client wants all of you to work together, and that you will do. Similarly, in a moot court competition, there's a factual problem at hand which is called moot proposition. You have your fellow colleagues, students, classmates, and you would want to present your best foot forward into that moot court competition. So choose a team, make a team which is enthusiastic about participating in that competition, has the necessary skill set. For example, you must have at least 2 good orals, people who can speak really well. You must have a person who is really interested in doing legal research. Ideally, all of the team members should be interested in doing legal research, but there must be one who is specially equipped into doing this. One more factor that needs to be looked into is that almost all the moot court competitions require you to submit a memorial. A memorial is a written document, and there must be, the team as such should be equipped to handle MS Word effectively, but there must be at least one person, because one core learning from moot court competition is how to use MS Word, and if you already have a person who knows MS Word in a really nice way, it can do wonders for your written submission. Your team should have researchers, speakers, and writers. Writers in the sense, and it's not necessary that these questions should be different people. It could be the same set of people having different skill sets. And the reason you need a writer is you need to draft a memorial, and a memorial requires crafty writing. It is very close to how you draft in an actual courtroom, how you draft actual pleadings before a court of law. The third most important thing regarding preparation is, by this time, you have identified what moot you want to go to, where is that moot going to be, and thirdly, you have made a team. Now, the most crucial part, and rather the first part to your journey, is researching the moot problem. Read the moot problem. There is no alternative to it. You have to read the moot problem again and again and again. I mean, as many times you read it, it will be lesser. It can't be more than sufficient. The more you read the moot problem, the more you will be able to get into the mind of the drafter who was drafting that moot problem. Now, every moot problem is drafted in a way that it has 2 almost equally balanced sides. You have to present your written arguments from both the sides, and most likely your oral arguments also from both the sides. So therefore, the more you read the moot problem, the better position you are in to understand what the problem drafter was thinking about when they were drafting this problem. The more you read the problem, a better analysis of issues can be done by you. First, you'll be able to identify what are the issues that the problem is trying to present. Second, why are those issues arising? And secondly, how can you resolve those issues? Reading the moot problem will allow you to think of multiple arguments that can be taken, and the more you read it, the more arguments you will find, and most likely you'll find certain facts which might align with certain case laws that you might come during your research. And the moment you find that, that's a very nice moment, because you realize, yes, this is really applicable. But even if you do an abstract legal research, go about reading case laws without reading the moot proposition, it is not going to help you, because the whole objective of finding certain authority, certain observations from court in already existing cases is to show that the same situation is there in a moot proposition, and hence the judgment you are citing is applicable. So your legal research gets structured in a good way, and you can present your arguments in a better manner if you have researched your moot proposition accordingly. The final thing with respect to preparation is understanding the rules of the moot court competition. There are some moot court competitions which will penalize you if your written submission is not as per format. But in case you don't know this and you just give a rough shot of written submission, obviously that is going to cost you. Every moot court competition on oral rounds will have a time limit. You will have to adhere to that time limit. If you practice speaking for half an hour while the time limit is only 30 minutes, it is going to cost you in terms of marks. You might not proceed ahead in the moot court competition. So therefore, select the moot that you would like, form a team that has the skills, research the moot proposition in a great detail, and fourth, go through the rules in a meticulous manner so that you unnecessarily do not lose out on marks. If I can give you an analogy from cricket, the Pakistani player called Babar Azam, he was playing a cricket match once. It was a one-day international, I guess, and he wore the keeper's glove in one hand and collected the ball. That cost the Pakistani team 5 runs. The only reason that happened was the only reason why it happened was because Babar did not know that only the wicketkeeper can wear gloves. Babar was not a wicketkeeper, wore gloves, and that cost his team 5 runs actually. Similarly, in a moot court competition, if you do not read the rules and you just go about getting into the problem, coming out with great solutions without adhering to the rule book, you might be doing really well. You might become the best mooter out there, but it is going to cost your team marks, which is not a happy scenario for anyone. So I'm hoping that all of you would really consider going through the moot court rules in a very effective way so that you need not lose marks unnecessarily. The third aspect for today's talk that I'm giving is legal research and case analysis. But before we proceed with this, does anyone have a question with respect to the two aspects we have considered? First, the importance of mooting, and second, the preparation that is required to participate in a moot court competition. I would love to hear if anyone has to add on to this or has any question with respect to what we just.
You can unmute yourself and can answer the question. Participants, you can unmute yourself and answer the question.
All right, so it's very close to lunch. I do not plan on keeping you for very long yet.
Hello, Gaurav sir. Can you please again explain the third point of preparing for a moot? Because you said that brainstorming arguments we have and analysis the case. So how can we analysis in a proper manner? Because when we find a fact supporting our case, supporting our moot problem, so how can we analysis in a proper way?
Yes, thank you, Kavish, for that question. Very important question. The more you read the moot problem, you will figure out that it has, let's say, thousands of facts, or at least 100 of facts. Not every fact might be that important. You have to first identify the skeleton of the problem, that there is a structure to this problem. These are the core issues that this problem is trying to raise. Your job as a moot court participant or as a lawyer is to address those issues. The more you read the problem, you will be in a better way to analyze what is the structure of the problem. Once you have identified the core structure, you can start underlining the ancillary parts, that this is also something that is relevant, but this is not the core, right? A good way of analyzing or brainstorming arguments is that the team reads the problem individually. I mean, if there are 3 members of the team, they read the problems in their own free time, and then they collect to discuss the problem through their viewpoint. The benefit of doing this is that all 3 of the team members will approach the problem from perhaps 3 different directions and can present certain viewpoints that one might lose out when they are reading it in a common way. Once this reading has been achieved, then you should come to a common conclusion, common consensus between the teams, between the participants, and then identify that these are going to be our core arguments. This is what we are going to lead with, and this is something that can follow up or can buttress that argument. So this is the way I did it, and this is the way most teams do it with respect to brainstorming arguments. The second level to this is the more you do reading of the material at hand. I mean, you'll have law books, you'll have case laws. And the more you do research, the more scenarios you will find that are similar to the problem that your moot proposition is raising. Once you are in that position to make that association between what you have found and what you have at hand, you'll be in even better scenario to brainstorm and then cull out the arguments that you would want to present in the moot. I hope I have answered your question, Kavish. Do you have anything else to ask?
No, sir. No. Please continue.
Thank you. There was one more hand raised. I'm sorry I could not note the name. Can you please speak if you want to speak? All right. So we'll move on to the next part, which pertains to legal research and case analysis, something that I was just talking about in the last slide as well. Legal research. Yeah. Pooja, you have a question? I saw. I'm sorry, I saw a hand. I mean, if you have a question, please do ask. It's all right. Okay. So the third component is legal research and analysis. Legal research for a moot court competition is very, very, very important, because a moot court competition hinges upon legal research. And when I use the word hinge, it literally acts as a connector. The facts and the law connect together to give you that platform so that you can do research. And legal research will involve reading articles by academics, doing statutory research, I mean reading about statutory law, rules, regulations, and all that, and also case law research. And it is a combination of everything that you will present going forward. Now, how you do that also depends on the structure of the competition. How you do that also depends upon the structure of the competition. If you are participating in a common law jurisdiction country like India, you might want to approach it in a different way. In a civil law country moot court competition, the strategy might differ, but this is something that really happens in advanced stages. We'll restrict ourselves to the basic stuff first. So of course you need to know how to read a book. Read a book in the sense, how do you find if the material that you're looking for is really inside that book? So most of the law books have an index at the back. Some keywords are mentioned. If you can see that index, find the relevant keyword that you might think is associated with your moot proposition, you will be able to use that book in a better way. Of course, you should also speak to your library staff who might help you with books regarding certain subject areas. And most importantly, it is paramount to know how to use legal databases. SEC Online, Westlaw, Manupatra, anything that you can lay your hands on. One good thing that has emerged is the Supreme Court Reporter, SCR, is now available for free online on the Supreme Court website. So even if you do not have access to any of the paid databases, you can also use legal resources that are available for free. So how do you use those legal databases is something that is there to be learned while you're in law school, I think it's better if you learn as fast as possible, because these resources are immensely helpful both in studying as well as going forward. And when you become an advocate and you need to do actual case law research, you must know how to use SEC Online or Manupatra or whatever software that might be there in your office. Without this, it's really difficult to practice law these days, and one really suffers. So using legal databases is one of the most important skills that you must already have to some extent. But for sure, if you participate in a moot court competition in a serious way, you will acquire that skill on a much larger scale, and it will make you a better law student and perhaps an advocate. Yes, Shruti, you have a question. Yes. I can see some people raising their hands. I mean, if you have a question, please feel free to unmute yourself and ask. Anyway, the third point regarding this topic is analyzing case law. You have read some books, you have perhaps marked some paragraphs from those books, some case laws that are mentioned in those books. You've also found those judgments using online legal resources or even offline like AIR and SEC. The next step that you need to do is read those judgments and understand how they apply to you. Not every part of the judgment is important for you, right? You would want to dwell on that part which relates to your moot proposition, which gives you a certain scenario which is closely aligned to your moot court proposition. How do you do that? Is by reading that judgment in a very careful manner and then trying to discern what a ratio is. What is the ratio of that judgment? Now, I have a question to the audience. Is there anyone who can tell me what is the ratio and what is obiter dicta? Is there anyone? I mean, yeah. Tanishka, can you please?
Namaskar, sir. So first of all, thank you for this question. Ratio recidenti means that is the reason of the judgment, and obiter dicta means it's the observation, debates, opinion during the judgment.
Yes, thank you. That's a fantastic answer. A ratio is the minimum reasoning that is required to decide that case. All right? And it is the ratio that is binding, not obiter. Obiter are certain casual observations that are made or something that does not really decide that case at hand. It is only the ratio of a judgment that is binding upon a lower court. For example, if you're reading a judgment from the Supreme Court and your moot proposition relates to the High Court level, and you have a judgment from the Supreme Court in your favor, the fact that you have a judgment is not going to be enough. You'll have to show it to the people who are judging you inside that moot court competition that ratio of the judgment is binding upon them. And for that, first you as a student, as a participant, need to discern, you need to find out what the ratio is. And what is the ratio is something, again, very contesting. There is no fixed agreement to what is the ratio for a particular case. But if in your understanding you come to a conclusion that yes, this case has been decided in a particular way because of these set of arguments, this is the reasoning behind the judgment, then of course this is the ratio. And this exercise increases when there are multiple judges who have delivered judgments. For example, in the right to privacy judgment, it is a judgment given by a set of 9 judges of the Supreme Court of India. Now, what is the ratio of the right to privacy judgment is something that really in nature of a question. You'll have to go through opinions of all the judges, find out the factors on which such cases were decided, such case was decided, such question was decided in this manner for that matter. And what is the minimum and what is the common standard by which the judges have judged. If you can find a common identifier between all the 9 holdings, then of course that will form the ratio of the judgment. and that is something that is binding. Anything else, for example, I will give you a quotation from Right to Privacy judgment itself. Justice Sanjay Kishan Kaul wrote an opinion, and in which he has said Uber does not have any car, Airbnb does not have any hotels, and all that. And yet they are such big companies, and privacy is important, and technology companies have grown so big. Now, this is a commentary on the state of affairs. Is this something on which the right to privacy judgment has been decided, or is it? I mean, is it really the core thing on which such a case was decided? The answer is no. These are paragraphs which act as fillers. A judge has multiple observations, but not everything might be the core observation which decides a particular dispute. The moment you are able to find out what is that core observation which pertains to your case at hand, which relates to your moot proposition, half the job is done. You really have done some good legal research, and now you can present it in the best possible manner. And this is what which leads to our next point, which is building legal arguments. Now, any legal argument will have to have some basis, either of statute, some act of parliament or of state legislature, or some rule or regulation made under that act, or a case law decided by a court, Supreme Court, High Court, or for that matter, any court. The moment you rely upon a judgment that has been delivered by a court, you need to see the jurisprudence behind that judgment. Yes, Anil, you have a question?
Yes, sir. Descending order is also important or not, sir?
Yes, I'll get to that. The moment you rely upon a judgment, you need to see the jurisprudence behind that judgment. How old is the judgment? How many times it has been discussed later on? Has it received positive treatment from the newer benches, the subsequent benches? And what is the impact of the judgment overall? If those things are going in your favor, I mean, if the judgment has really strong backing, then of course it's a good judgment to rely upon. The thing with dissenting judgments that Anil has asked is a little bit shifty. For example, ADM Jabalpur was a case that was decided by a number of judges, but Justice H.R. Khanna gave a dissenting opinion. I'm hoping all of you would know that. That dissenting opinion formed the minority part of the judgment as per the date of the judgment. But we all now know that the majority of the judgment in ADM Jabalpur is something that does not hold good ground today. It is the minority opinion that is celebrated, right? So if your reading gives a viewpoint that yes, the dissenting opinion is something that will act in my favor, and most likely when such scenarios occur, the moot proposition is framed in a particular way that you are facing an equivalent forum. I mean, if you're relying upon a dissenting judgment of the Supreme Court, the moot proposition will also put you before the Supreme Court. You get an opportunity to show your mock Supreme Court that here is the time to reverse what was held earlier and make the dissenting judgment something that should hold the ground. For example, in the Aadhaar case, one of the grounds was whether Aadhaar is a money bill or not. Now, this is fairly technical. Money bill has to be introduced in Lok Sabha. There's a certain framework that governs money bill and not. Justice Chandrachud delivered a dissenting opinion, if I remember correctly. And although that was dissenting, in yet another matter that might come up before court, that dissent can be effectively used by lawyers who are present in that case to show that even though Justice Chandrachud was in minority and actually in dissent in the Aadhaar case with respect to this viewpoint, now is the time to reverse that. Of course, our judiciary has undergone a tremendous change. Things that were held to be law before are not law anymore. So you rely upon that organic nature of the law and plead your case in such a way that a dissenting opinion of yesterday can translate into positive opinion for today or for the future. That is how you go about it. But of course, with that dissenting opinion, if you can do some further research, let's say that dissenting opinion has received good commentary from academics, you can show that the nation or the judiciary was not ready at that time to hold it in a particular way, and therefore this opinion was in dissent, or the statutory regime was such that this opinion was in dissent. Now the law, the statute has changed, and therefore this case needs to be held in a different way. You'll have to put that dissenting opinion with several other factors, including commentary by academics and contemporary analysis, to show that that dissent of yesterday holds no longer good for today. I hope I have answered your question, Anil. If you have anything to add, please do.
No, sir. Thank you, sir.
All right. So, yeah, Rainy Tower, you have a question? All right. Coming on to the next thing, building legal arguments. Or you have done some research, you have found positive judgments or dissenting opinions that are going to help you put your case before the court, before the moot court. But you need to put those arguments in writing first, and they should be clear, concise, and persuasive. Clear and concise are very important. If you write something in a very hazy way, in a way that cannot be comprehended, it is not going to do any good. If I start speaking to you in a language that you don't understand, this conversation that we are trying to have will not make any sense. So whenever you write legal English, it is important to not focus on the fancy words, but it is important to communicate well. Your message, your point of view, your argument as a lawyer should get across to the judge so that they are able to understand it, process it, and then accordingly grade you for it. So be very clear. Do not go unnecessarily long into your legal arguments. Most moot court competitions will even restrict the number of pages or the number of words that you can use in written arguments. You'll have to be concise, be brief, be persuasive. And that is the whole point of this activity, is that you become a better lawyer as such. And a lawyer generally has the ability to persuade a judge or a person to a particular viewpoint. Your argument should also be drafted in such a manner. Be formal. It is not a casual conversation that you're having with a friend. A moot court competition is a serious business, and therefore use formal English. And whenever you give any legal reasoning, be sound in it, back it up with citations. So therefore, you see all the footnotes that are there in a moot court memorial, because teams are trying to give their sources for those arguments. Therefore, it is, the effort is to show that the legal reasoning that is presented is sound in nature. All right. This is a very crucial part. I'll be happy to explain something again if somebody has not understood, or if somebody has a question with respect to all of this. Any questions so far? Yes. Yes, Titania. I think you can unmute yourself and ask.
Good afternoon, sir.
Yes.
Good afternoon, sir. I'm a student of semester 1, and the law subjects I have are law of torts and law of contract. So, sir, can you tell me what kind of moot court competitions I can participate in?
Yes, Titania. That is the challenge one faces as a first-year law student. You have read torts, you have read contracts. You'll barely find any competitions that are focused on just 2 subject areas that you have studied. A moot court competition also gives you the opportunity to study something further, a subject that you might not even encounter in law school. So if you pick up an arbitration law moot, an arbitration law is a subject that will come only later. By participating in an arbitration law moot, you can learn arbitration faster and earlier. So what I'll suggest is that look at the list of moots that are available to you, find out a subject area that might interest you, and then, of course, when you talk about commercial law-based moot court competitions, they will involve an element of contract law. So it's better if you focus on them and look for a moot that plays to a subject area that might interest you going forward. something that seems interesting, and then it's better if you go for that moot court competition. Somebody else had also.
Thank you so much, sir.
All right. Somebody else had raised their hand.
Gaurav sir, you said
Yeah.
that dissent in present case is
Mhm.
apply in future or reverse
Mm.
the judgment. Suppose in EWS reservation judgment, Justice UU Lalit dissent. Suppose in future, if someone is going to reverse the judgment in the court, so what will happen? Uh, who get reservation through that period, total period?
Okay, so what you're talking about is the effect of the judgment. There is something called retrospective application and prospective application. Usually, in all policy matters, the policy is to have a prospective application. Let us say there is a certain reservation that is existing in the country. I mean, certain percent of overall number of seats are reserved, and that number gets changed after 10 years. Most likely, it will be a prospective application. That is, the operation of the judgment that is pronounced after 10 years will start from the date of the judgment or from the date of the from the date that judgment specifies. Rarely, almost never, has any judgment been applied retrospectively. In such cases, for sure. So yes, that answers your question. Anybody else as well? I remember seeing some other hands. Yes, Sophia.
Yeah, sir, could you please explain brainstorming argument with example?
Sorry, can I explain?
Brainstorming argument with example because I'm not getting what you want to say.
Yes. So brainstorming means discussing with your friends, with your moot team participants about what arguments can we put. For example, let's say your moot court competition deals with an instance of murder, and there's a gunshot that has been fired. One way to lead it could be that there was an eyewitness to this incident, and therefore this person can testify that this was murder. The second way to lead this would be that the ballistic report matches with what the accused was holding in hand, right? The third thing would be the DNA found at the spot or some investigation, the forensic investigation that has been done. Now, these are multiple arguments that might support your case, right? Not every person is in a position or has done the legal research to come up with all the arguments that I am putting forward, right? I mean, if you have dealt with ballistic part, most likely you're going to come up with ballistic parts in a better way. In a team, you are 3 people minimum or 2 people minimum. So what you can do is you discuss such ideas, you discuss such arguments, and then you make a list of those arguments and then see which is the most effective one, which is the strongest argument to make. And that becomes your leading argument, your first argument in your moot proposition as well as oral argument. And that is how you lead with your case, with your presentation during the oral rounds. All right?
Yes, sir, got it. Thank you so much, sir.
Thank you. Any other question? Yes, Muskan.
Good afternoon, sir.
Good afternoon.
Sir, court visiting is also helpful for moot court competition?
Definitely. I mean, if you do internships and you go to court, you will see how lawyers are interacting with the judges. And that will give you an idea about the etiquette that is used, the mannerisms, the dressing sense. All of that is very helpful. The arguments by itself, final arguments would be very helpful for a moot court competition, but the process is actually the reverse. You should learn from a moot court competition in order to be a better advocate in court. Of course, you can reverse it as well. I mean, you can learn from an advocate and do better at moot court. But with respect to oral presentation and the way things happen in a courtroom, a moot court competition is slightly different. So you'll have to keep that understanding in mind.
Thank you, sir.
All right. Any other question? Okay, we'll move on to the next part. Yes. Writing memorials. Now I'll go faster with this because I think you have dedicated sessions on drafting memorials and all that. Memorial is a written submission that you present in a moot court competition. It is governed by certain format. Every moot court competition will tell you the structure of the memorial. For example, some might ask you to write facts in brief in a single page. Some might want you to write a paragraph on jurisdiction. Some might want you to list out your arguments in a very skeletal form. Some might want arguments advanced, right? So whenever you participate in a moot court competition, read the rules of the moot court competition, see what is it that is being expected from you, and accordingly you structure your memorial. For example, whenever, let's say you have a case at hand and you go to court, you file a petition, right? A petition or an application or a suit, depending upon what kind of matter you're going to file in court. In moot court competition, such things are called memorial. They are your written documents based on the party you are representing. In a moot court competition, because it's a practice kind of a thing, I mean, it's a mock court, right? You will get a chance to present your written arguments from both the sides. Yes, Rekha, you had a question? No. So first thing in a moot court competition, follow the rule book seriously, diligently, and limit yourself with respect to the word limit, page limit, and all that. A moot court memorial is graded. Sometimes your future progression in that competition depends upon the memorial, and therefore take it with all seriousness, because this is a place where you can score full marks, so as to say, because everything is textual. How to write persuasively, give good citations is something that you will learn with time and practice. If you are relying upon a book, let's say, how many times that viewpoint has been relied by judges is something that can be really helpful. Now, there's a book called Chitti on Contracts. There's a Mullah as well, I believe. Those are celebrated authors. And when you give their viewpoints, they are taken seriously. But if you give a very common author, something that is used by students only to memorize for exams, that might not work really well for a moot court competition. The whole point is that whenever you present your legal arguments, you should give them good, sound legal authority. And that authority comes from established jurisprudence. It has to be there in some form. You might come up with a novel argument, but if you break that argument into certain pieces, you will see that those pieces are also flowing from somewhere. You'll have to show those somewhere and those pieces. And that is what makes a good written argument. There are some mistakes that you should avoid. Of course, not exceed the page limit and the word limit, but be clear in your language. If there is no need of using Latin phrases, do not. I mean, some phrases inter alia or bona fide have become part of traditional English, legal English by now, but do not go searching for legal maxims when there is no need to do so. If you want to cite something, give proper and complete citation. And when you are acting for the respondent, you'll have to address the points that the petitioner has raised, right? Be very thorough in countering such arguments. These are some common things that you have to take care of while writing a moot court memorial. Of course, you'll have to write memorial from both the sides. And when I say both sides, I mean all the parties that are there in that at that dispute. So usually a petitioner and a respondent. And be very thoughtful when you're drafting this. Whenever you're doing research, I used to take 2 colored pens and then mark one for each. I mean, if I found a point favoring the petitioner, I would mark it down color, and for respondent, I'll mark it in a different color, so that when I go through my research, I'm able to understand what is what and what favors whom. That is a good way of doing research, and then translating that research into written arguments in form of memorials. Anybody has a question with respect to memorials? Yes, ma'am. Yes, Ibrahim, you can ask.
Good afternoon, sir.
Good afternoon.
Sir, I have one question.
Yes.
From Vivekananda Global University.
Yes.
Sir, what is the difference between admission with notice serve reply file and fresh admission with state bail? So, sir, I want to know just the difference between the two.
Can you repeat what you said?
My question is admission with notice serve reply file.
Okay, I think it's better if you write it in the chat box, and then I'll be able to understand it in a better way. Because what you're talking about, like if you notice the reply to the file, is more in nature of a court order that this member usually pass. So it's better if you write it in chat, and then I'll answer your question. at the end.
Okay.
All right.
Yes, sir.
Because the phrase that you're using has to be really proper, and I would want to know what exactly are you using. And there's some echo as well, so it's better if you give it to me later.
Yes, sir.
All right. Thank you.
Thank you, sir.
Anybody else with a question with respect to memorials? Yes. Yeah. Kanishka, I can see your hand. Yeah, Momal as well.
Good morning, sir.
So my question.
Yeah, Momal first. I think she raised her hand.
Good morning, sir.
Good morning.
Sir, I have heard the word companion many times. So, what is the difference between memorial and companion?
Yes, thank you for that. So memorial is the written argument that we present to the courtroom, right? To the moot court competition, to organizers. They will check it, they will mark you for it, and that is your main petition, main submissions in a very structured form. Now, let's say you are relying upon 5, 6, 10 judgments in your memorial, but judges do not have a copy of those judgments, or you're relying upon certain articles that are published in law journals or in the press, in media, or anything that you want to show in documentary form, which you could not attach with your memorial. For that, you make a separate booklet, separate compilation, which is called a compendium. A compendium will usually have statutes, I mean the full law. If you're relying upon a particular provision, you can give that particular provision in your compendium. You can give complete judgments in your compendium. You can give law journal articles, anything that you want to rely upon to convey your point to the judge in a courtroom, that is apart from your memorial. So memorial will only be as per the structure that is given by the competition. Anything else that you want to show, you'll have to put it in a different booklet called the compendium. It is not necessary to make a compendium in most competitions, but teams that have done good research and have something to show usually make a compendium and give that compilation to judges during the rounds. I hope I have answered your question, Mohammed. Yeah, Kanishka, please.
So I wanted to ask, what's the most crucial part while writing a memorial, and what are the challenges that we face while doing it?
The most crucial part is to not make mistakes. You might not be very creative with your memorial. I mean, your memorial might not be a standout memorial and still do good because you did not make mistakes. Usually the mistakes are typing mistakes, typos, formatting mistakes, and citations. If you can take care of these 3 things, your memorial is already a decent memorial. Now, from becoming a decent memorial to a good memorial, of course, strong legal research will be a good factor. More the citations, the better it is. Perfect structure is amazing. I mean, if everything is as per the competition format, your font size, your line spacing, your margins, everything is as per competition format, amazing. The third thing is, how do you lead your arguments? First, do you start with the law, or you start with the facts, or you mix facts and law? Is in nature of presentation, and that is really something very individual to each team. There is no fixed rule for it. But what I did as a practice was that I wrote the facts first, and I led with the facts, then some law, and then married facts and law to present my argument in a comprehensive sense. That is what I did, and that is what perhaps make a good memorial.
So, sir, facts are the crucial part that we need to focus on priorly.
I mean, see, if you focus only on the facts, then that is not going to be a deal breaker. Of course, facts are the most crucial part because you have a factual problem at hand. But the objective of a competition is to ensure that you mix facts with the relevant law. So after you have introduced your facts in an argument, let's say it's a breach of contract kind of a thing, and you show the conduct of a party that this party has like breached the contract. Then the next consequent step is to deal with what is the law on breach of contracts. Done. Once this is performed, the third step is to mix your facts with the law on breach of contracts and then show what kind of remedies available to you. This is a three-step process. Start with a little bit of facts, something that is crucial and important to that particular issue. Write the law for that particular issue, and then mix the fact and law. All right?
Okay, sir. Thank you, sir.
All right. Anybody else with a question? No problem. Fifth point, oral advocacy. The most glamorous thing as such, but not necessarily the most important. But it becomes important when you go for rounds. There are many moot court competitions which will first do a screening. So, I mean, for most moot court competitions that have become really prestigious, they cannot have so many teams coming over and presenting oral arguments. So they screen teams on the basis of memorials. If your memorial is not good enough, you will not make it to the oral rounds. But once you have made it to the oral rounds, you need to be good to proceed further into the competition. One thing that is there about orals is that how do you address the judges? This depends whether you're participating in an international law moot, in an arbitration, or in a national moot court competition. So style yourself accordingly. Be very clear with respect to what you say, how you say. Be a little slow, especially in moot court competitions. As Indians, mostly we are used to speaking in a very fast manner, and it becomes a bit challenging for people who are not used to this way. So it's better if you speak slowly, speak in a measured way, and most importantly, follow the moot court etiquette. It is not a playground that you've gone to. It is a serious setting, a court in which you are presenting your arguments. So your attire should be such, the way you speak should be such. It's not a debate competition where you can raise your hands and make points like this. Your hand should be reserved, and you should be very polite. It is a conversation between a lawyer and a judge in order for the lawyer to assist the judge to come to a better solution. It is not an angry match between the judge and the participant. Sometimes it becomes so, at least the participants feel it so, because the judges are asking too many questions and difficult questions. But that is not the essence of the competition. The judges are only testing whether you can remain calm and composed during a hostile question answer session. All right. So anticipate what questions judges might ask and answer them accordingly. If there is something that you do not know the answer to, be very clear and say that you do not know the answer to that question. How do you say it is also of significance, and I'm sure your workshop on oral advocacy will take care of all such mannerisms and will go into further detail. But most importantly, remember that you have to look presentable because looks matter, and you have to speak slowly, carefully, in a measured way, and speak everything that makes sense. Just do not be casual with the way you're speaking. Any questions with respect to oral arguments? None? Okay. Yes, Anil has a question.
Sir, ये oral advocacy is the part of the moot court or a different competition?
It's part of the moot court competition in the sense that you have to present your oral arguments, and that is what I called as oral advocacy in my slides. Once you have submitted your memorial, then you will get a chance to appear in a mock courtroom where you will have to plead your case orally before the judges who are going to grade you. So yes, that is how oral advocacy becomes a part of moot court competition.
And the other team also the present at a time?
So there are two teams in a moot. One, let's say, is the petitioner. The second is the respondent. The petitioners will speak first, and the respondents will then get a chance to reply. This is the oral round, and after this, the teams get a chance to do a rebuttal and a sur-rebuttal, right? So a team gets the chance to reply to what the other team has said, and the second team also gets a chance to reply to what the first team said. Yes, Shruti has a question. Oh, sorry, Anil, I mean, does
Okay,
that
sir.
satisfy?
Okay, sir. Thank you.
All right. Yes, Shruti?
Yes, sir. I have a question that how can I improve my legal research skill for moot court cases?
The only way to improve your legal skill is, I mean, until unless you do not have specific facts at hand and you're working in abstract, then I'll suggest you start reading more judgments. Start reading websites like Live Law and Bar Bench. It will keep you updated and you will get to know of recent judgments. If you encounter actual scenario in your moot court competition, it will obviously be help to you later on. If you have a moot court competition already at hand and you're working for it, use as much of SEC Online Westlaw, whatever tool is most helpful for you for that particular subject matter, and read more and more, and you will find more arguments. And the only way to enhancing your research skills is to do more research and even read more furthermore.
Thank you, sir.
Thank you. So you'll have to understand what a moot court competition is like to participate in it the best way. Know what is the scoring criteria. That is important because that is the criteria on which you will be scored. I mean, of course, you're doing it for learning and for fun also, but if it's a competition, you would want to win it, right? And the way to win it is, you know, the rules of the game. The rules of the game for this instance would be the scoring criteria. What is it that you're being judged on? And accordingly, you can decide what is it that you want to focus on. There are some general guidelines on which judges score. They see your legal analysis, they see your presentation skills, they see your oral arguments, they see your demeanor, they see your dressing sense as well. They see the answer to the questions that they are asking, and those are crucial factors. One space where you can easily score well is time management. If the speaking time allotted to one person is 15 minutes and they finish in 10 minutes, that is obviously going to look bad. If they finish in 13, that's still okay. 15, perfect. But if that becomes 17, 18, 19, that is a cause of concern. Yes, Narendra?
Good afternoon, sir.
Good afternoon.
When we go for legal analysis, what are the criteria which we look for?
So a judge is really looking whether your legal analysis is based on something. I mean, if a question has been asked to you and you reply to it without there being any legal basis to it. For example, if the judge asks you on what grounds could this have been done, and in your reply you do not cite any law, do not cite any judgment, do not cite any opinion, then of course that is an opinion coming from your personal side, and that does not hold any value. Your statement should be backed by something, and that backing is a result of the analysis that you did before entering that courtroom to speak. So this is what judges are mostly looking into. With what stuff are you backing your arguments?
This contents?
Content of your argument should match with what you have written in your memorial.
Okay.
And your memorial should be based upon certain materials that are available. And those materials could be the law itself, statute, or judgment, or academic opinion, or something which is of use to you, like expert opinion, if it's a technical matter.
Thank you.
Thank you. There's one more hand. Yes. Shwalini Priti, I guess. All right. So coming to time management, if you take too much time, it is going to cost you. If you are proper, it's better. And teamwork is important.
Excuse me, sir.
Yes.
Good morning, sir.
Yes, good morning.
Can you provide tips for effective public speaking and presentation skill in moot court?
See, one way to improve your skill is to speak in front of the mirror. I mean, even when you are alone and you want to speak on something, take a topic, write something on it and speak in front of the mirror. That will make you a confident speaker. If you have become confident speaking alone, start speaking to your friends. Ask one of them to be judge and start speaking in front of your friends. They will ask you questions, and this practice will make you better. Chetna?
Yes, sir. Good afternoon, sir.
Good afternoon.
Actually, I want to ask, can we state readings of the reports for like backing our statements?
What kind of reports?
So reports that will support our statement.
I mean, what kind of report? Are you talking about a news report, a report by the government authority?
Sir, any kind. Like
Yeah, so you
what?
can take use of any material, but that material has to be relevant, and that material has to be solid. For example, let us say you are relying upon, you want to say that such an incident has occurred, and for that you rely upon a news report published by the Indian Express or Times of India or the Hindu, one of the reputed newspapers. All right,
Yes,
that has
sir.
more weightage than something that has been reported on a shady website somewhere.
Okay, sir.
So you
So
have to
like I
take
have
care
to
of.
go for the authenticity.
Yes, definitely.
Okay, sir. Thank you.
All right, thank you. So time management is crucial, something that you can easily do. Teamwork is something that you learn throughout this process. And if you are able to crack this code of working together, of course, you'll get friends for life and you'll be able to do good in that moot court competition as well. Some practical tips: time management, as I said, teamwork, collaboration, talk to your friends, talk to your participants, talk to your teammates, understand what they are going through. Some might be going through a hard time, help them out. You will also seek help at times. It's okay to be nervous. Don't be very nervous. The more you practice, the less nervous you will be. A lot of preparation can easily, throw away that nervousness from any stage. Don't worry about it. Do not be very sad if you do not do well in a moot court competition. Judges are usually tough, but that's there for a reason, because when they were participants, they also faced tough judges, and it's the circle that is ongoing. Don't feel too bad about it. Whenever a competition is done, and even if you have done good or not so good, assess what went wrong or what went good and what could have been improved. Life is all about self-reflection, and so is the competition. And accordingly, you learn from your experiences. And if you are doing too good in a moot court competition, let's say you win a moot court competition and there's no learning experience that is gained from it, but there is a person who lost in the first round but has understood what went wrong and has learned from the experience, I think the second person is in a better condition. Not all moot court champions end up becoming the stalwarts of the legal profession. Not all participants who lose in the first round, do nothing in life. It's just a competition. You'll get a chance to perform in an actual courtroom when you become a lawyer. So do not take this competition to heart. There is a lot that you can do in subsequent competitions as well as real advocacy whenever the time comes. And if you have any further questions, I'll happy to answer. Otherwise, that's all from my side. I hope, I think I kept myself in time. Yes. Any questions with respect to the competitions or the strategy or anything else for that matter? Yes, Anand.
Sir, I just, regarding the previous question as per media reports.
Yes.
So can we be penalized for citing secondary or circumstantial evidence? Or is it subject to the rules of the competition only?
Definitely subject to rules of the competition. Mostly the competitions will give you a factual scenario. So, you will not be able to invent on facts. But if you want to correlate with something that is very recent, about which the only source you get is a media report, and that is how you show similarity of facts with respect to something, of course you can show the media report, but please make sure that it's authentic, it comes from a very reliable source.
Thank you, sir.
Thank you. Any other question? I'm still waiting for that text from Ibrahim. Ibrahim, I'm sorry I could not hear you properly. Then can you please type it out? Was by what you had said, issue notice and reply to be filed. It's usually language used by judges in actual court. What they do is, whenever a new petition comes up before them, issue notice means serve a copy of this petition to the respondents. The respondents are put to notice. That is, now you have this petition at hand, reply to this, and that is what a reply is called. So issue notice is putting the respondents to notice with respect to an application or petition, and now the person to whom notice has been given needs to file a reply. Yes, Zara has a question, I guess. Zara, you can ask your question. Zara or Ibrahim, I mean, if you would want to proceed.
Sir, I understand the first question that I asked, clearly understand.
Okay.
And sir, the other one is the fresh admission with state bail.
Okay, fresh admission and stay. Is that what you're asking?
Yes, sir, fresh admission with state bail.
Okay, nice. So let us say you have gone to a government authority with a grievance, and the government authority has passed an order which is not in your favor, and you want to challenge this before a court of law. You file a writ petition before a high court. So a high court will examine your matter for the first instance. It will come as a fresh matter. So it will admit that matter, and accordingly, when your matter is admitted, it will be admitted in the court of law, and the parties will have to file a reply. The parties need some time to file a reply, the respondents, all right? Till the time the reply is filed, what would your position be? I mean, there's a government order against you, and prima facie, that should not have been the case, or even if that order subsists, you will suffer great harm, and it's okay if that order can be stayed. The effect of that order is stayed, temporarily stayed, till the time the other parties file the reply, and then the court can examine it whether to continue with that stay or not. So in those situations, the court pauses the effect of that order that was against you and will consider restoring the effect of that order once it has got the reply from the other side. So this usually happens at the initial stage, during admission stage, because that is when the parties need it the most. That okay, my lord, I have come to court, and please protect me, please grant me stay against this order. And the court does that. I hope I have answered that question, Ibrahim.
Of course, sir. Of course, sir.
All right. Thank you. There's one more question from Priya. Yeah.
Hello, sir. Sir, I have a question. So I want to know which are the subjects gives us this scope for mooting.
I mean, most moots you will find are there in commercial law. So you will find arbitration law moots, and then there are some specialized law subjects. You will find space law, human rights. On the national level, investment law is again a common theme. Criminal law. Then there are different kinds of moot court competition, like trial advocacy. So obviously involves criminal law and involves a criminal trial. Constitutional law is like always there. And yes, these are some important areas in which you find moot court competitions.
And sir, we cannot cite English articles in our mooting competition, right? Memorial.
When you say articles, if there is a opinion published by an academic in a journal, you can say, see, there is no, I mean, unless the competition rules bar you from doing so, there is no restriction on citing whatever you want to cite. If you follow, there are mainly two guides of citation, now Scholar and Blue Book. They give you a format on citing anything. You can cite a personal communication or letter. So there is no bar on citing anything. But of course, this depends on the rules of the competition.
Okay, sir. Thank you.
All right. I see another hand, Bhagyashri. All right. Zara, your hand is still there. Tejpek, I mean, yeah, if you have a question, please.
Hello, sir.
Yes, hi.
Sir, I've taken part in my college freshers moot and also intramoots.
You have to be a bit louder. I mean, there's another.
Sorry. Hello, sir. Can you hear me?
Yes.
Sir, I wanted to know like how the judges are like a participant because what I've observed and like the feedback given by the judges, they said like the research is more important than the speaking because if you don't have a logical flow of arguments, then the person who has a better research will win. So can you
Definitely. See, the competition is not about testing your speaking skills only. All right. I mean, you could be a terrific English speaker, but if your arguments are not based upon logic and substance and legal research, that is going to be a hindrance for you. So the effort is not to speak English with a flair or English with an accent, but to present solid legal arguments in a structured form, and that is what one should focus on. Even if you are, let's say, not so good with the language, but if your presentation is proper, if you're methodical, if you are structured, that is going to hold you good.
Okay, sir, thank you. So, like, how do we like work on this then if we are like
Practice with your friends, practice with your faculty, ask them to be your judge, and give a mock around before you go for an actual competition. The more you practice, the more you'll figure out where you are lacking and where you can improve.
Thank you, sir.
And one good way of learning is to watch YouTube videos of moot court competitions, see how other speakers are doing so. Many times you can really pick up skills from others, and that's a good way of learning.
Okay, sir, thank you.
Thank you. Yes.
Thank you.
A few more questions. Yeah. All right. As per what the organizers say.
Yes, sir. Thank you, everyone. Sir, we will just wind up the session and take the queries in the next sessions.
All right. Yeah. If you have any questions, feel free to reach out to me. I'll be very happy to answer. And all the best with your moot court journey. And thank you again to the organizers for inviting me for this. And it was a pleasure speaking here.
Thank you, sir, for generously imparting your wisdom and enriching us with your valuable experience. It was a pleasure listening to you. I request everyone to kindly turn on your cameras for a group screenshot. Thank you, everyone. Now, I would like to invite Ms. Purnima Gautam, ma'am, faculty of Rajasthan School of Law for Women, for delivering vote of thanks. Please, ma'am.
Thank you. Greetings to all. It's an honor to have been asked to propose a vote of thanks for this enlightening session on the fundamentals of mooting. Moot court competitions definitely help the students to learn the art of articulating the legal skills, which is essential for law practice and will eventually expose and acquaint them to the challenges of education. Now, first of all, I, on behalf of Rajasthan School of Law for Women, would like to extend my heartfelt gratitude to our esteemed guest speaker, Mr. Gaurav Pathak sir, who spared time from his busy schedule and gave a vivid outlook on the advantages and benefits of mooting. He stressed on various aspects of mooting, like choosing a best moot, researching on the intricate issues, preparing an argumentative speech, preparing the memorial and its format. There also enlightened students on the task and importance of researcher in a moot and how his role is significant to a participating team. He also took precepts from his profound experience as a mooter. The students have gained valuable insights into the world of mooting, from understanding the structure of a moot court competitions to owning essential skills like argumentation and presentation. Thank you, sir, for giving deep insights into the topic and for patiently answering all the queries. Next in line, I would like to extend my sincere thanks to our respected Principal Ma'am, Dr. Partika Arora Ma'am, for being the catalyst that stimulated us to do our best and standing as a pillar of strength and for extending immense support in organizing this event. Thank you, ma'am. I'm immensely thankful to the people who have been the backbone of this event: Dr. Disha Bangadwa, co-convener, Ms. Palak Vashisht, organizing secretary, and Ms. Khanjan Sharma, organizing secretary of this workshop, for organizing this session. Thank you, ma'am. I also extend my profound thanks to all the staff members for their enormous cooperation. Thank you, everyone. I would also like to thank volunteers and our team who worked tirelessly to make this session possible. Thank you, students. Next in line, I would like to thank all the participants for joining the session. I'm hopeful that this session will enhance your skills to become a good mooter. Thank you, students. I also extend my hearty vote of thanks to the moderator, Ms. Anjali Sharma, for moderating the session so well. Thank you, Anjali. Once again, I thank you all for your cordial cooperation. Thank you, everyone.
Thank you, ma'am. Before ending the session, a reminder for all the participants to fill out the feedback form as is provided in the chat box of the meeting, and in order to receive a participation certificate for the workshop. Thank you, sir, and thank you all the participants for joining. Hope to see you in the next session. Thank you.
Thank you, sir.